My Lords,
Yes.
I have just one or two further points on the merits
Yes.
that I should like to take your Lordships to, if I may. Should like to go back to the Senate, which is at tab 58
Yes.
and page 499. Now, my Lords, the Senate, number 2, that decision of the House of Lords does appear to be the highest authority on what on the merits means. And at E, Lord Brandon of Oakbrook is drawing a distinction between decisions that are on the merits and decisions that are purely procedural. And his Lordship says, the argument in relation to the first contention was that the judgment of the Dutch Court of Appeal was procedural in nature. And then, skipping on a bit to F, he says, in my opinion, this argument is based on a misconception with regard to the meaning of the expression on the merits. And although this is an issue estoppel case, the principles are the same for cause of action estoppel. Looking at the matter negatively, a decision on procedure alone is not a decision on the merits. Looking at the matter positively, a decision on the merits is a decision which establishes certain facts as proved or not in dispute, states what are the relevant principles of law applicable to such facts, and expresses a conclusion with regard to the effect of applying those principles to the factual situation concerned. So, my Lords, in the hearing of the conviction complaint, what was decided? Well, they looked at the facts. Certain facts are not in dispute. The failure to comply with the direction, that, as we've already been taken to, was not in dispute. That there was a conviction before the Royal Court of Jersey, that fact was established. And then there was a lengthy discussion on the law that applied in the tribunal, of course, being the bylaws. There was a great deal of discussion between the legal advisor to the tribunal and the Institute's advocate, who was presenting the case for the Institute. There was a lot of discussion about the law, a lot of ventilation of the facts, and then a conclusion was reached, which was that the Institute had failed in the conviction complaint. Now, going back to Williams and DP...
Your position, as I understand, is that no facts were proved. So, you would have to add, I think, to Lord Brandon's list here. It can be a decision on the merits if if the result of the thing is that nothing's been proved.
Well, plainly, that sort of analysis, my Lord, could be applied to any unsuccessful prosecution.
Yeah, is that not a decision on the merits?
An unsuccessful prosecution.
Yes, His Lordship talks about looking at the matter positively, a decision which establishes certain facts as proved or not in dispute. But supposing it finds that certain facts are not proved.
My Lord, in the summary of the conviction complaint, which your Lordships have already looked at this morning, it was found that it was not in dispute. In fact, I think the very words, "it is not disputed," that Mr. Coke-Wallis breached the Jersey direction. So that fact was not in dispute. The crucial thing that wasn't proved was what the Institute, on the way it had presented its case, what the Institute needed to prove to establish the conviction complaint. And on the way the Institute had presented its case, it needed to prove that there was this corresponding offence, and it couldn't do so. It didn't then do what it should have done in my submission, which was to either ask for an adjournment to amend or go under 7.3b. It didn't do that. But the Institute failed to establish what it wanted, what it believed it had to establish. But there were facts, nonetheless, that weren't in dispute. So, if I might take your Lordships back to Williams and DPP, about which there was some discussion this morning.
I thought that they held that it was not proved that there was a breach of the regulation. And that's the critical point from your client's point of view, surely.
On the way the complaint was framed and presented, they failed to establish that there had been the conduct in Jersey that underlay the conviction. They failed in the legal way to establish that as proved for the purposes of the disciplinary bylaws.
So what I put is correct then. They failed to prove that there was an infringement of Regulation 4.
Yes, absolutely. I'm not, my lord, suggesting that everything in that decision hangs together sensibly as a matter of logic. On the one hand, the conduct's not proved, but on the other hand, they make all these findings of fact that go directly to the conduct. So, my lord, I'm not suggesting that it hangs together as a sensible, logical disposal of a case. It's not.
I mean, I thought it was a very dangerous thing to concede that it was found that they were in breach of the regulation, that all the facts led to the inevitable conclusion they were in breach of the regulation. It was a very risky thing to assert from your side's point of view, but there it is.
My lord, I was making no assertion and no concession. I was simply highlighting the plain words of what the tribunal in its wisdom said in different parts of its decision. I'm not making any concession.
Well, I thought you were making these points because you wanted to demonstrate that this was a decision on the merits.
Yes, I am, but by reference to the tribunal's decision. There is a distinction, my lord, between the way, the technical legal way the bylaws were applied and other parts of the tribunal's decision. That's really why it's caused so much difficulty. Now, my lords, if I might take your lordships to Williams and DPP, which is at tab 64. And I'm going to page 1169. And there is there, my lords, at C, a quotation from the minority judgment of Mr. Justice Lush in Haynes and Davis, but that minority judgment has been applied in a number of cases on which the Institute relies. Mr. Justice Lush found in Haynes and Davis, it is just as much an acquittal upon the merits if the judge or the magistrate were to rule upon the construction of an Act of Parliament that the accused was in law entitled to be acquitted, as in law he was not guilty, and to that extent expression acquittal on the merits must be qualified. Now, my lord, that is really the kind of approach, even putting the Institute's case at its highest. That's what happened. In that perhaps there was it was a technical application of the bylaws, but nonetheless a real application of the bylaws in the sense of being a construction of those bylaws. And turning the page to 1170, at F, the judge in Williams and DPP turns to the qualitative question. And the judge records that the prosecution had framed the charge incorrectly and, by referring to the specimens of breath rather than blood, had put themselves out of court when it came to proving the charge. Now, that's very important in my submission for drawing a distinction between a decision on the merits and a decision not on the merits. If we look at the witness evidence of the Institute's Tracy Owen at page 219 of the appendix, which can be found at tab 15 of the appendix. And there's no need for your lordships to turn to it because it's simply one sentence, which I might read out.
So which paragraph?
It's paragraph 83, my lord, which is at page 219. And Tracy Owen says, given that, as is illustrated in extradition jurisprudence, the concept of a corresponding offence is sometimes a matter of legitimate debate, and so on. Now, that is very important because it shows the way the Institute approached the conviction complaint. As we know from the Appendix 3 documents, Mr. Coke-Wallis had ventilated the view that what he had done in Jersey would not be regarded as criminal in England. Now, we know from the correspondence of Mr. Jowett that the Institute took a contrary view. It went and asked a Jersey policeman what he thought. We don't need to worry about whether that was an appropriate thing to do or not. That is the course of action that the Institute took. And it's the fact that the Institute saw the question of a corresponding offence as a matter of legitimate debate that distinguishes this case from Williams and DPP, because the Institute didn't put themselves out of court. The Institute very much put themselves in court, because there had to be a legal discussion, on the one hand, on the part of Mr. Coke-Wallis putting in his submissions, on the other hand, the Institute's advocate, who went to the tribunal and, as the transcript shows, forcefully and diligently argued that there was a corresponding offence, but was ultimately unsuccessful. Now, my lords, that is a disposal on the merits as the Institute characterised those merits. Now,
on the merits of the particular dispute, as it was.
Yes, which is the way the conviction complaint was framed.
Yes. May I say that at the moment I have reservations about the second way that Mr. Justice Rougier decided this case. On his approach, if you imagine that somebody's driving at 50 miles an hour and a 30 mile an hour limit, and there's a speed camera and also a policeman with a radar gun, and they prosecute him for exceeding the speed limit on the basis of the speed camera, which is then shown actually to have failed to satisfy some statutory requirement, so that it's not admissible as evidence. If Mr. Justice Rougier is right, well, they could prosecute him again for speeding and call the policeman. And I find that very questionable.
My lord, it depends how far the prosecution gets. On Mr. Justice Rougier's analysis, if it gets to the point where everybody realises what's happened before it's even been pleaded to and it's dismissed, then perhaps, and I'm not...
That's the temporal point, that's the first point. But his second point was an alternative point. If justice was done according to the law, there was never any possibility that he would be convicted on this particular approach because of the technical or the legal bar. Therefore, he was never in jeopardy. Therefore, he can be prosecuted again.
Well, my lord, I certainly wouldn't resist if your lordship is minded
I'm just putting
to...
a marker down so that Mr. Beloff isn't in any false sense of security.
If your lordship is minded to decide that Mr. Justice Rougier was wrong in Williams and DPP on the qualitative point, then I certainly wouldn't resist that conclusion. But I would say, as a fallback position, that our case is completely different because it did go all the way to a full disposal, having had a fully argued hearing on the merits, which didn't happen in Williams. Now, if I may just anticipate a point that the Institute is likely to raise because they raised it in their Appendix 3 note, and that is the point that the subjective view of the Institute about whether they were going to win or not, or whether they had an arguable case, is irrelevant. What matters is the application of the legal principles. Well, my lord, in my submission, if the Institute is right, then there is no stopping off point between any case where there is an argued hearing, where all the legal principles are ventilated, and it's decided that one side is right and the other side is wrong. There's no stopping off point between cases where there is jeopardy and there is no jeopardy, because in every case one could say, well, you see, they lost, so there was never any possibility that they were going to get home on that one. Now, my lord, those are my submissions on the merits, and yes, with your permission, your lordships, I will now hand back to Mr. Jones.
There's just one point. I suspect it may be for Mr. Jones, but which is concerning me, and that's the applicability of this jurisprudence to disciplinary proceedings. There may be all sorts of reasons why there are regulatory requirements that can lead to disciplinary proceedings, and one is the protection of the public.
Yes.
And if you imagine regulations designed to make sure that surgeons are competent or airline pilots are competent. The idea that if there had been disciplinary proceedings to withdraw a pilot's license on the ground that he was simply incompetent, and the proceedings had been incompetently conducted so that the charges had failed on a technicality, the idea that you couldn't have a further investigation is rather horrifying, isn't it?
Well, it is indeed, and I don't doubt, although I don't know,
Yes.
but I don't doubt that there's all sorts of special statutory and other regulation for airline pilots and other people who are operating dangerous machinery that means that if there's any doubt at all about their competence, then they can be taken off the job in pretty short order. But this is not a question of competence or otherwise, Mr. Coke-Wallis, it's misconduct. But as to the point of principle, my lord, it seems to be more or less common ground that res judicata applies between disciplinary tribunals as between themselves. Now, my lord, the Institute has brought forward lots and lots of authority to show that disciplinary tribunals aren't like other forms of proceedings, most particularly that the principal objective is protection of the public, not punishment of the offender, and it's that whole line of authority from Bolton and Law Society. We take no issue with any of that as far as it goes. What we say, though, is that none of that authority says that you can have more than one go in the same jurisdiction. There is simply nothing before the court from which that conclusion may be derived. And although it was it was ultimately decided on abusive process rather than res judicata, but the Australian case of Walton and Gardner, which is very much on point and which my learned friend Mr. Jones will take you to when he talks about abuse. Walton and Gardner, it was two sets of disciplinary proceedings, and it was very much the case that abusive process did apply. And I would submit to your lordships that as between a first set of proceedings in a particular disciplinary tribunal and a second set of proceedings arising out of the same matter in that same disciplinary jurisdiction, there is an absolute application of cause of action estoppel, and there is simply no authority anywhere to support the proposition that there isn't. Every authority that the Institute has produced is between different jurisdictions. There's what we might call the Redgrave principle, where a criminal prosecution doesn't preclude a set of disciplinary proceedings, and vice versa. Or the case of GMC and Swanee, which no doubt your lordships will be taken to, where there was disciplinary proceedings that barred the doctor from practising in Canada and disciplinary proceedings that barred the doctor from practising in England, and there was no abuse or res judicata or anything else as between those proceedings. But the point is they were different jurisdictions, Canada and England, different. The point is you can't have more than one go in the same disciplinary tribunal, and in my submission, the Institute has got no authority to support that. I will now hand over to Mr. Jones, who will take your lordship through abuse of process.
Yes.
Yes.
My Lords, if it be found that the first complaint is in fact the same as the second complaint, in our submission that's covered by the strict rule of res judicata. If in fact it is found not to be the case, it's not strict, it's not the same, then of course we move on to the principle of abuse under the case of Johnson Gore Wood. And it's to Johnson Gore Wood, my lord, that I would like to draw my lordship's attention to. Johnson Gore Wood is found at tab 19, my lords. no doubt fully aware of the facts of this case, where two actions were brought. The first action by the company in negligence, the second action by the individual, Mr. Johnson. Referring to the judgment of Lord Bingham at page 30, the bottom of that page, take it up from H, it may very well be, as has been convincingly argued, refers to the academic publication of Watt, convincingly argued that what is now taken to be the rule in Henderson and Henderson has diverged from the ruling which Wigram VC made, which addressed raised judicata. But Henderson and Henderson, abusive process is now, as now understood, although separate and distinct from cause of action estoppel and issue estoppel, has much in common with them. The underlying public interest is the same. There should be finality in litigation, and that a party should not be twice vexed in the same matter. This public interest is reinforced by the current emphasis on efficiency and economy in the conduct of litigation in the interests of the parties and the public as a whole. The bringing of a claim or the raising of a defence in later proceedings may, without more, amount to abuse if the court is satisfied, the onus being the party alleging abuse, that the claim or defence should have been raised in the earlier proceedings if it was to be raised at all. Now go to halfway along C. It is, however, wrong to hold that because a matter could have been raised in earlier proceedings, it should have been, so as to render the raising of it in later proceedings necessarily abusive. That is to adopt too dogmatic an approach to what should, in my opinion, be a broad merits-based judgment which takes account of the public and private interests involved and also takes account of all of the facts of the case, focusing attention on the crucial question whether in all of the circumstances a party is misusing or abusing the process of the court by seeking to raise before it the issue that could have been raised before. This is the next sentence at E. Thus, while I would accept that a lack of funds would not ordinarily excuse a failure to raise in earlier proceedings an issue which could and should have been raised, then I would not regard it as necessarily irrelevant, particularly if it appears that the lack of funds have been caused by the party against whom it is sought to claim. While the result may often be the same, it is, in my view, preferable to ask whether in all of the circumstances a party's conduct is an abuse than to ask whether the conduct is an abuse, and then, if it is, to ask whether the abuse is excused or justified by special circumstances. My Lord, my submission, what that is saying, and I will take it up by a subsequent judgment in Stewart and Goldberg, what, in my respectful submission, Lord Bingham is saying here is that the question that should be asked in assessing abuse is whether the matters that arise in the second action should have been raised in the first. And as he puts it there, it should be a broad merits-based judgment, taking into account all of the interests, taking into account all of the circumstances, public, private, and special circumstances. Of course, special circumstances is absorbed into this principle of broad merits-based judgment, And Lord Bingham, in fact, raises one possible set of special circumstances that can be taken into consideration. My Lord, the important point in my submission is this, that when one assesses the situation, and it should be assessed at the time the second action is brought or being considered, all of the circumstances that one considers then should be considered from a retrospective point of view. One looks back to say, okay, in the light of all of these circumstances that have transpired since, or that have existed, or that we now consider, we now look back retrospectively and ask the question, should this action, these facts, this case, have been included within the first set of proceedings? My Lord, if I may develop that point one step further.
Well, is that right?
My Lord?
Because that sounds as if you're saying that the question whether it should have been raised in the first proceedings, if answered in the affirmative, will necessarily be determinative of the question of abuse. But that surely is not what Lord Bingham is saying. That if it should have been raised first time round, that may be a strong pointer towards abuse. But you've got, in deciding whether or not to expose somebody to a second round is an abusive process, you have to have regard to all the circumstances.
My Lord, indeed. And it is all of the circumstances that one does have regard for in assessing or in answering the question, which is, should it have been brought in the first occasion?
Well, I'm suggesting that the key question is whether it is an abuse of process to expose the person to a second lot of proceedings, and that the key question is not whether the point should have been raised first time round, although whether that question is obviously a very important question in the overall judgment that has to be made.
My Lord, I understand that point.
Well, do you accept it or do you disagree with it?
Well, my Lord, on a strict understanding of Lord Bingham, I disagree with it. My Lord, the reason why is that Lord Bingham, in my respectful submission, is seeking to determine what are the ingredients for deciding whether something is an abuse or not. The next question flows, well, the abusive process is the bringing of a second matter that should have been covered by the first. And he is saying there, the question is not what could have happened, but what should have happened. And in deciding what should have happened, one then looks at all of the circumstances, looking backwards. But, my Lord, can I'm not putting that point on hold, but could we look, please, at the case of Stuart v. Goldberg, that may put a further light on the point that is being made by Lord Bingham. It's found at...
Which point? That
the point that one looks at all of the circumstances, the public interest, the private interest, the interest of all parties, but looks back in answering the question, should it have been brought on the first occasion?
Does it make any difference on the facts of this case, whether you apply that test at the time that the first proceedings were put in train, or today? Because at the moment I'm not aware that there is any difference in the material circumstances.
My Lord, in these circumstances, the mischief that we're seeking to address is the suggestion by the Institute that the fact that they are a public body, the fact that they have, or not a public body, but the fact that the role they play has particular significance within the community, that there is a overwhelming, or if not an overriding, public interest that gives them a special license for them to bring a second set of proceedings, which they should have brought in the first place. and it is purely to address that point, whether the public interests should be considered prospectively or retrospectively. We say that there is no authority for the Institute to proceed on the basis that they have special license to bring a second set of proceedings when they should have brought them on the first occasion. And in support of that submission, I rely on the judgment or the judgment of Lord Bingham. And it really goes to that point, and that point only. The point I do, however, make clear, although I don't know if it applies here, but I think it's right to say and emphasize, is that the time when it's determined whether one should have brought it or could have brought it, putting could to one side, because if it should, then it is an abuse, is at the time the second set of proceedings are brought. The question then is raised, looking back, well, in all of the circumstances, should it not have been brought? Now, there are authority to say that there are circumstances that one would consider to be relevant in assessing whether it should have been brought or not, that come into play. In the case of Johnson Gore Wood, the set of circumstances that, well, in fact, there are 2 points that flow from Johnson Gore Wood, whereas Mr. Johnson was impecunious as a result of the actions on behalf of the firm Gore Wood. That was held to be a set of circumstances that would weigh heavily in assessing whether the action should have been brought in the first place, and therefore he couldn't afford it. One has to look further into those circumstances to see why. The second point, and this comes up later in the case of Talbot, the second point, set of circumstances that could give rise to the conclusion that the matter should not or need not necessarily have been brought the first time round, is if there was prior agreement, which of course was the case with Johnson, in the case of Johnson Gore Wood, where he made it quite clear that he was bringing the first set of action against the firm, or the company was, but he reserved his right. Well, my lord, that is an important point. That is a set of circumstances that can come into play later in deciding whether the matter should have been taken on the first occasion. In those 2 examples, it weighed heavily in favour of the claimant, of Johnson, because there were special circumstances. But those circumstances were, if I may repeat the expression, applied retrospectively, even though they were only considered subsequently.
I mean, Lord Bingham says the bringing of a claim or raising a defence in later proceedings may, without more, amount to abuse if the court is satisfied the claim or defence should have been raised in earlier proceedings, if it was to be raised at all. May. He doesn't say it will. And he goes on to explain that it's a broad, merits-based approach, and you take into account public interest and all those sorts of things.
My lord, may I just...
B, letter B.
Thank you. The bringing of a claim, may I just repeat this? Yes. My lord, I understand this, the word.
But it's giving effect to it.
My lord, yes. And of course, that may well be the case. I'm not... The may impacts upon the consideration of all of the interests, the public interest of the party, the private interests of the party, whether there are any special circumstances. So, yes, there is a may there. There is a consideration there I say consideration rather than a discretion, but the may impacts on the weighing of the factors, the weighing of the circumstances, the consideration of the interests of the party, the circumstances, what was brought, why it was brought. In this particular case, of course, it was fully within the powers and the consideration of the Institute to have brought the proceedings correctly in the first occasion. But to answer my Lord's point on may, and of course that is right, but the may hangs in abeyance when one considers all of the factors, and then in consideration of all of those factors, one then looks back and asks the question, should they have been brought on the first occasion?
You assume the starting point is, and this thing is, you assume that he should have been brought on the first occasion. Then you look at all these other factors, public interest, all that sort of thing, and you say maybe whether it was difficult for them because of money or all these kinds of things, and then you say, looking at it overall, is it an abusive process to allow it to be brought in on a second time? That's what Lord Bingham is saying.
My Lord, I wouldn't necessarily disagree with that. I wouldn't necessarily, because, and the only reason I do that is looking at the same coin, but from a different perspective. We still have to get back to the question whether it's a should or a could. If it's a should, after considering everything, then we say it's an abuse. May I just extend it one further without leaving the point? And that is to go to divider 55, if I may. Tab 55, I should say. Pinching my thumbs. This is the case of Stuart v. Goldberg. Lord Justice Lloyd giving the main judgment. This was a case where there was a claimant bringing a successful action against the defendants for a breach of undertaking, and then a second action was brought against the same defendants alleging different causes of action arising nevertheless from the same facts. Looking, my lords, at page 839, and I take it up from paragraph H. In fact, rather than take it, I don't...
It would help me, at any rate, if you were to
My
say
Lord, sorry?
It would help me, at any rate, if you were to say what you're going to get out of this case.
Yeah, my Lord, what I'm getting out of this case is to expand upon the point that's made by Lord Bingham in assessing what is meant by the Board's merits approach and what the relevant questions are in asking the question. Particular case here, the point that came up here is whether it is a consideration as to whether the case was the second case, whether it was a weak or strong case. It was being argued that if a particular case is overwhelmingly strong second time round, then it should be allowed through.
Is that relevant here?
My Lord, not those facts, but what is relevant here is exactly what, in my submission, Lord Justice Lloyd says. It's at the top of page 840. I'll take it up from there, where he says, in my judgment, when Lord Bingham spoke of a broad merits-based approach, the merits he had in mind were not the substantive merits or otherwise of the actual claim, but those relevant to the question whether the claimant could or should have brought his claim as part of the earlier proceedings. a defendant may feel harassed by having brought against him what appears to be a weak claim, but that factor should not count in this context. Whether the claim appears to be weak or strong, it's the fact of it being brought as a second claim, where the issue could have been raised as part of or together with the first claim, that may constitute the abuse. So, my Lord, the only point I'm taking from that is that one is not considering the substantive merits or the strength of the actual claim, but whether the claim could and should have been brought in on the first occasion. And applying this, my Lord, to our case, when one considers the documents within Appendix 3, it is quite clear that whether they accepted it or not, or whether they considered it or not, they were put on notice that this case that they were attempting to bring under, or attempting to prove under bylaw 7.1, was not a comparable equivalent offence here. And my Lords, the only point, and it's a simple point, is that is something that they should have done the first time round. They did not, and they're stuck with it.
Is protection of the public part of this exercise?
My Lord, it's very much a part of the exercise, but what that means is that they should have got it right the first time round. The public interest does not, and there's no authority to say that it does, the public interest or the public element that the Institute seek to rely upon is no licence for them to have not to have done their job correctly in the first place. My learned friend, Mr. Cole, made it, I think, clear, I'll repeat it if I may, where the whole matter could have been corrected is that once they were before the disciplinary tribunal, once it being found that there was no comparable offence here, to have simply sought an adjournment. And then we fall in line with the various judgments, cases, authorities, Williams being one of them, that the line of peril is not crossed. But as soon as one moves into the merits of the case, and in particular, and I think this is where we may have got confused earlier, that the merits does not necessarily mean the facts. The merits of the case, quite equally, can refer to the law as to whether this is a charge that could stand up. And of course the charge could. The charge under bylaw 4 was perfectly respectable, effective, and could, and of course is used here in this jurisdiction. Where they failed was on an evidentiary point of view, but that matter should have been considered, and I stress the word should, have been taken and considered at the beginning. And it was within the ambit of them to do so. One's only got to consider the words of Miss Tracy Owing within her affidavit, within her witness affidavit, where she sets out why they didn't do it, what could have been done. But more importantly is this point as to whether it was going to be an effective application, an effective hearing of the complaint. And the effectiveness of that complaint depended upon the tribunal deciding whether Miss Peto was right or wrong in submitting, as she did submit, that one of those sections of the Financial Services and Markets Act was sufficiently comparable to the offence. She failed. But, my Lord, that doesn't mean another tribunal wouldn't have taken the same view. Another tribunal may quite easily have taken the view that, that this was sufficiently comparable. And it's not as though Miss Peto just made a one or two line set of submissions. She made very forceful, extensive submissions on the point. And that has to be looked at in the light of the information that they were given ahead of the hearing. It was made quite clear. But when one reads the documents in Appendix 3, it's quite clear that the officers, an experienced solicitor, an experienced barrister, didn't look far enough. There's a reference to D.C. Grieve, an officer in Jersey, just giving them an account of what an indictable offence is. Nothing more. Well, of course, the question and the focus should have been here. If they have access to highly trained, competent lawyers, the question easily could have been raised here. But of course, when one considers, and we needn't read it again, when one considers the position put forward by Miss Owen, Tracy Owen, that this was subject of legitimate debate, are very powerful telling words. If that was the line and the view they took, that yes, this is something that we could succeed on, and we are going to try to succeed upon it.
Do you say that the judge and therefore the Court of Appeal misdirected themselves when exercising this abuse of process jurisdiction?
My
and
Lord,
if so, in what way?
Yes, my Lord, yes I do. In that where the courts below heard was that they applied a prospective application of the circumstances, and they took into consideration the fact that this was a body exercising powers that has significant public interests, and as a result of that, looking forward, that, according to Mr. Justice Owen, that according to the courts below, gave licence for them to ignore the law, ignore the principles of res judicata, on the basis that this was a set of circumstances that enabled them to go forward. But of course, that set of circumstances did not explain away, which was necessary, as to why they didn't do the job properly in the first place. So that's the error.
Do you dispute that they were entitled to attach weight to the fact that there was a real public interest involved here?
My Lord, in deciding whether to bring the second action or not, they were not entitled.
They were not?
No.
But Lord Bingham says broad merits-based judgment which takes account of the public and private interests involved.
My Lord, yes.
And I thought you said, when I asked you that same question, that the public interest was relevant.
But my Lord, public interest was relevant, but the question is, relevant in what respect? It was relevant in deciding whether they should or should not have done it in the first place. For instance...
but the should in this context, it means, I think, after looking at all the circumstances, because this area of abuse or res judicata is about cases where, as a purely technical matter, the claim could have been brought in a second proceeding because it wasn't covered by the first proceeding. And Henderson, and all the rest of it is about the public interest in ensuring that parties should bring all relevant matters in the first action.
Yes. My Lord, I agree with all of those points. Where, with the greatest respect I part, is that the consideration of the public interest doesn't allow them, it does not give them license to do what they should have done in the first place, unless there is acceptable reason for what they did not do in the first place. And there is no reason put forward, none whatsoever, as to why they didn't get it right the first time.
So you say that the public interest is a factor, but too much weight was given to it by courts below.
My Lord, no. I think I may not be making it quite clear. What I am saying is that if that is the way forward to decide whether we can proceed a second time round, then public interest doesn't give you license to do so unless you, looking back, can explain why you properly, why you didn't do it correctly in the first place. You see, my lord, the Institute have this duty, and we can see the responsibilities that flow from it. But they have to do it correctly from the beginning. Otherwise, it gives license to other professional bodies, be it doctors, be it lawyers, be it accountants, that the public expect a high standard. What that means, if we are going to say, well, because they are a body that exercises powers that have a public interest on application, then the fact that they didn't do their job properly in the first place doesn't really matter, because they can do it a second time or a third time. Why? Because they are a public body, because they are a body exercising powers that have particular public interest. So what I am saying, my lord, is that yes, public interests are very important, particularly in the context of this this case. But before it comes into play and gives them license to do what they should have done in the first place, they must explain why, from a public interest point of view, they did not do it in the first place. And that's where the retrospectivity comes into it. I'm just looking, my lord.
But even supposing you're wrong about that, surely what you can say about the Court of Appeal is that first of all they erred in their whole approach to whether the earlier decision was a decision on the merits or not, and secondly they should have held that the Institute should have brought the two cases together.
My lord, yes.
I would suggest to you that those, if there are any errors in the Court of Appeal, that's where they are.
My lord,
I must...
My lord, yes. I accept that. And
But all the cases say you have to test it at the institution of the second proceedings. All the cases say that. And all the cases say you have regard to what happened before. You surely have regard to all the circumstances of the case. Sometimes things have changed between the first set of proceedings and the second proceedings, as, for example, in the Court of Appeal case we were just looking at. And so you just look at the whole case and decide, looking surely forward and back, taking account of all the circumstances of the case, whether or not it's an abuse of the process. Surely that is the correct.
That is, but if I may take that one step further, in deciding whether it should have been brought in the first place.
Now, I'm assuming that you don't get off the ground at all unless it should have been brought in the first place. If it should have been brought in the first place, then Lord Bingham says you test the matter at the second stage and asked whether, in all the circumstances, a new set of proceedings would be an abuse of the process.
My lord, yes. Back to...
Not retrospectively, but in a way prospectively.
Well, my lord...
Since we're all interested in what's going to happen afterwards.
Well,
so
we are, my lord...
The question whether they're an abuse of the process looks to what's going to happen in the future.
My lord, of course, that cannot be ignored. But looking at it, in deciding the law as to whether it should have been brought or not, that's where we look at all of the circumstances, we look at everything to decide whether it should have been brought in the first place.
Yes, well, you've made that point several times.
I have, my lord, and before I do, in fact, I needn't repeat it, but in my submission, that's exactly what Lord Bingham is saying at paragraph D at page 31. May I just read it once more, and then I'll leave it at that point, where he speaks that this is to adopt too dogmatic an approach to what should, in my opinion, be a broad, merits-based judgment which takes account of the public and private interests involved, also takes account of all of the facts of the case, focusing attention on the crucial question whether in all of the circumstances a party is misusing or abusing the process of the court by seeking to raise before it the issue which could have been raised before. So, my lord, it's those final words which is the focus and the reason as to why one is looking at all of the circumstances, all of the interests, to decide whether it could have been raised before. My Lord, as a result of those questions, which I welcome, I think I can move on swiftly. There is the case, and no doubt my learned friend will be making reference to it, the case of Ria Solicitor. This is the case that is another set of special circumstances. In fact, a good example of special circumstances where the conduct, we'll move away from it, where a solicitor I'm hesitating on the word embezzled, but there is a question of honesty, and the matter was brought before the Law Society, and a complaint was levied, was preferred. And that complaint was in respect of his discreditable conduct, which impacted upon honesty and a client account. He was duly dealt with and disqualified for a period. Subsequently, there was a conviction, and the Law Society then brought a separate action based on the conviction. And it was held that that was a set of special circumstances that could explain away why the case was not brought in the way that it was the first time round. And of course, the simple point was, simply, as Lord Wolfe made it quite clear, the only reason why this unusual case came back a second time was because there was no conviction the first time round, and the conviction made the whole matter a little more serious. It was an academic examination of the factors because they decided that they wanted the court's view on this as to what should happen. But in that case, yes, it falls under the heading of special circumstances, but illustrates perfectly that it is applied retrospectively, because they're looking at the reason why the complaint was not brought in the way that it was the second time round, and whether it should have been brought. The explanation being that it could not have been brought in the way that it was subsequently because there was no conviction. My Lords, the final point on the subject of abuse that I wish to bring my Lord's attention to, is this marked, is the case of Wharton Gardner.
Which case?
Subject of...
Sorry, which case?
Wharton and Gardner. It's found in volume 8 and tab 79. And Lord, this was a tragic case where the first set of disciplinary proceedings were brought and focused on the treatment of certain named proceedings. The first set of disciplinary proceedings was stayed, and then there was a commission, an Australian Royal Commission was commenced over a period of some 8 or 9 months, with the report being delivered some 5 years after the disciplinary proceedings had been initially commenced. There was some very disturbing details emerged that indicated that the conduct of the doctors was about as serious as anything could ever be found against doctors.
What are you going to get out of this?
The point I'm getting about this, my Lord, is that the public interest of doctors being disciplined in the subject of conduct that was wholly discreditable, wholly outrageous in all respects, was found to be an abusive process, notwithstanding the great public interest that had to be taken into consideration when deciding whether to allow the second set of proceedings to come or not. That is the point of the point, and I can take it up at. This doesn't help you consider it. Yes, but where's the paragraphs? My Lord, I would go to page 389. In summary, the new complaints are not the very complaints that were previously stayed, but they arise out of the same pattern of professional conduct as gave rise to the earlier complaints, and there is a substantial degree of overlapping between the issues to which the new complaints give rise and the issues that would have arisen under the previous complaints. It's 79. I take the second paragraph.
Sorry, what? Where?
Page 395, the second paragraph. In its application to the tribunal, the concept of abusive process requires some adjustment to reflect the fact that the jurisdiction of the tribunal, which is not a court in the strict sense, is essential.
Essentially.
Protective.
Essentially protective, i.e. protective of public in character. Getting this here.
Well, it's the top of 396. It's again a balancing of all the factors.
Yeah. Lord, I'm grateful. Yes, that is the point. Top of 396. The question whether disciplinary proceedings of the tribunal should be stayed by the Supreme Court on abuse of process grounds should be determined by reference to a weighing process similar to the kind appropriate in the case of criminal proceedings, but adapted to take account of the differences between the two kinds of proceedings. In particular, in deciding whether a permanent stay of disciplinary proceedings in the tribunal should be ordered, consideration will necessarily be given to the protective character of such proceedings and to the importance of protecting the public from incompetence and professional misconduct. And my Lords...
Is my learned friend going to read the next sentence, which
Yes.
your Lordships may feel is critical to an understanding of this judgment?
Thank you. As we read their Honours' judgments, the members of the Court of Appeal all utilised such an adapted weighing process in the present case. Yes. My Lord, the final effect of that was that, notwithstanding the abuse, if I can put it that way, and the conduct that became clear after this 9-month investigation into what the doctors did and did not, their acts and their omissions, their acts and default. Notwithstanding that, the fact that it was not covered some years earlier when the disciplinary proceedings were first brought was sufficient in the assessing of all of the circumstances, assessing what should have been brought into consideration or not, was sufficient to answer the question in the affirmative that all of this should have been brought in the first place, notwithstanding the impact that this would have on the community, and notwithstanding the huge public interest that would attach. My lord, that really is the point that flows from that case.
As far as I can see, they say everything's relevant.
Yes, exactly. My lord, yes. And I'm not going to repeat the points already made. So, my lords, that's in effect the elements of our main submissions. There are other points that may well arise, and accordingly we reserve our position by way of reply when I hear exactly how my learned friend, the Honourable Michael Beloff, how he presents his case.
Yes, thank you. Yes, Mr. Beloff.
My lords, there appear to be three separate purposes of this particular appeal. The purpose of the appellant, as it has been throughout these proceedings, is to nullify a finding of professional misconduct that has been made by the respondent's disciplinary tribunal on the basis of what we say is an unmeritorious technicality, and to allow him to retain his membership of the respondent body. The respondent's objective is to retain the judgments that they had in their favour below, and to be enabled to exercise the jurisdiction that they enjoy in the public interest, bearing in mind the circumstances out of which these disciplinary proceedings were initiated. Can I just, without labouring the point, remind your lordship of what the Royal Court in Jersey said? They were the court of competent jurisdiction. I'll read you the passage. It's not in the core volume, it's in the second volume of the appendices, just for your lordship's note, at page 444. The Commissioner of the Royal Court, who happened to be Sir Richard Tucker, a previous judge of the High Court, in sentencing stated, Piers Coke-Wallis and Natalie Coke-Wallis, each of you has been convicted after trial of failing to comply with the direction issued by the Jersey Financial Services Commission. Despite your denials, the evidence was compelling. It showed a flagrant and deliberate breach of a direction which the jurats, as your lordships knows, the finders of fact in the jurisdiction in Jersey, expressly found to have been served upon you, or rather upon the second defendant, Natalie Coke-Wallis. The jurats, by their verdict, found you had jointly planned to flout that direction, and that you did so 3 days later. And my lord may also be aware, as one gathers from that statement in the sentencing, that Mr. Coke-Wallis himself did not choose, although of course he was able to, give evidence before the Royal Court. He chose to put his wife forward, and she was disbelieved on the only critical issue, namely whether he was aware of the direction. Against that background, it's hardly surprising that the Institute felt it appropriate to seek to bring proceedings against Mr. Coke-Wallis. As my Lord the President observed, the shortcut, and my Lord, taking the phraseology I was myself going to use, but will now adapt what was a shortcut thought to be to establish a disciplinary offence, proved in fact to be a cul-de-sac. But I would go further and modify that and say actually it should have been a road marked danger at the outset. My Lord, the third interest which I mentioned is the interest of this particular court, because your lordships may recollect that the reason that permission was given to Mr. Coke-Wallis to appeal to this, to the Supreme Court, is set out in the second tab of the core volume. It was a decision given by Baroness Hale, by Lord Collins, who is in fact given a gender reassignment in the covering letter for reasons we didn't understand, and my Lord Clark. And your lordships will recollect, we were invited to focus in particular on these issues. Firstly, the correct approach to autrefois convict and acquit, and in particular, do the principles in Connolly apply to disciplinary proceedings? And secondly, the correct approach to abuse of process, in particular, do the principles in the same case apply to disciplinary proceedings, and is the test one which requires special circumstances to be shown before a second set of proceedings permissible, as stated by Lord Devlin in Connolly and the CACD in Beattie, or is it a broad merits test, as stated in Johnson and Gore-Wood, and by the Court of Appeal in this case, and if neither, what is the test? Now, your lordships will know that we sought faithfully to respond to these questions, and the answers that appear in short from our printed case are that we say that the autrefois convict and acquit have no application to disciplinary proceedings of a regulatory body. And in relation to the second, we say that the clear answer is there is a broad but merits-based test as stated in Johnson and Gore-Wood. We do not, with respect, understand my learned friend's submission when he seeks to qualify what we consider to be an agreement with our position in relation to the first, when he says the doctrine does not apply but the principles do. In our respectful submission, the principles are the doctrine and the doctrine are the principles. Now, my lord, the only case, and again my learned friend appeared to change gear or reverse direction from his printed case, was the case of Harry Wee, which he said, rightly, the Privy Council appeared to hold that the principles of autrefois convict and acquit do apply to disciplinary proceedings. Now, my lords, the reason I mention this is that we have sought, as best we could, to respond to that first question in some detail, reference to the purposes, the different purposes of criminal and disciplinary proceedings, by reference to the reasons why, in fact, it's both unnecessary because of the doctrine of abuse of process and undesirable because of the inflexibility of the rule to apply the criminal procedures or concepts to disciplinary proceedings. And we've sought to show from the wealth of jurisprudence, both in this jurisdiction and in the Antipodean jurisdictions, that that is the common conclusions of courts, that however one looks at it, whether one looks at it in terms of criminal proceedings preceding disciplinary proceedings or vice versa, or even two sets of disciplinary proceedings, none of those attract the two doctrines. Now, my lord, I am unaware as whether, since my learned friend, apart from a reference to Harry Wee, has not sought to pursue this at all, but because we were asked the question whether your lordship actually wish me to engage with that aspect of our printed case, or go straight to the matters upon which my learned friend relies, which are initially res judicata in the alternative abuse of process. In a sense, I shall be saying little more than we said in our printed case. I'll obviously be taking your lordship, if required, to the authorities. It may be that you wish some assistance on Harry Wee that we sought to deal with. Effectively, we're saying it was obiter because it was decided on abuse of process. No argument was advanced to the effect that the doctrine of autrefois convict and acquit applied. It's contrary to principle, because if one looks at Connolly and sees a divide between criminal and civil, one has criminal double jeopardy, autrefois convict and acquit. Civil res judicata serves the same general public purpose. And Lord, that's our position, but I don't want, as it were, to allow the matter to go by default.
Yes, go straight to abuse of process.
Could I just raise one point on Harry Wee?
Yes.
It seemed to me, but I read it perhaps too quickly, that what Lord Bridge was saying was not actually obiter. What he seemed to me to be doing was to be applying the majority in Connolly, the Lord Morris approach, to reach a conclusion on autrefois acquit. Yeah. But then go on to say, but in any event, if necessary, we can deal with it by abuse. Now, it may not matter because I think everybody now accepts that the Lord Devlin approach to autrefois acquit is the correct approach, but I'm not sure that it is right technically to say that what was said by Lord Bridge was arbitrary.
Well,
What I had in mind was, I think it's a page 369,
yes.
where he's having set out a passage from Lord Morris.
Yes.
He says at C, if the language of these propositions is suitably modified to apply to professional disciplinary proceedings, they are clearly apt to apply to circumstances under consideration in the instant case.
Yes.
And then he refers to Lord Devlin.
Yes. Yes.
And then he says not easy to see whether the majority agreed with Morris or Devlin, but it's unnecessary for the Lordship to express any conclusion in that regard. And then he says, if the facts cannot be brought within Lord Devlin's strict test, then they're certainly covered by abuse.
Yes.
Perhaps not entirely clear, but I read him as saying, applying Lord Morris, then this case is caught by...
Yes, well, if he was, the first point is, if he was saying that, there's been jurisprudence since that date, which makes it clear that the strict view of Lord Devlin is the correct view, including a judgment of this House or the House of Lords in the Rezed case. But the way that I read this, although he espouses that, what he is saying is, let's not worry too much about which is actually right, because we can decide this case on the more flexible test, that's the abuse of process test. And then, of course, it was a fact-based decision, and there are various ways in which the facts can be distinguished, as facts always can, from the facts of this case. But what we don't want, in particular since the Supreme Court invited this issue to be dealt with, is to have speeches from your lordships which say that, in fact, autrefort, acquit and convict apply to disciplinary proceedings, because in our submission, the jurisprudence, the policy, the purpose is all against that, and we were invited to deal with it. And if your lordships are prepared to accept that we not have shot our bolt in our printed case, but have set out fully that which your lordship hoped to see from us, then I'll take it as read.
There's quite a lot of American authority to that effect as well.
There's quite
a lot of American authority.
Exactly, so, yes, as I say, probably if we'd gone west as well as south, we would have found it.
Well, let's take that part of your case as read.
Yes.
And then moving on.
Yes.
First, I would like to know whether you seek to support the reasoning of Mr. Justice Owen and of the Court of Appeal to the effect that this was not the same cause of action, if you like to use that expression, the second time round, because I'm bound to say at the moment I don't accept that reasoning. It seems to me that it was a second bite at a different bit of the same cherry.
Yes. I know. And with respect, my lord, I disagree, let me put it as courteously as I can, I disagree with the submissions that have been made by the appellant's counsel, both on the construction of the bylaws and the construction of the several complaints. And it may be useful, if I may, to start by looking at those instruments. What we do say, and I shall take you to this in due course, because no doubt it's more felicitous than I can, that we consider that the President of the Queen's Bench Division, Sir Anthony May, put it entirely accurately, the analysis in paragraph 20 of the Court of Appeal's judgment. And my lord, may I start then by drawing your lordship's attention to the bylaws themselves, which in the core bundle volume you will find at 7 of 6. Now, my learned friend is quite right in a sense that there are two sections that one needs to consider, or two sets of articles. There are Articles 4, which is the liability of members and provisional members of disciplinary action, and there's also Article 7, which deals with proof of certain matters. And one sees that the nature of the bylaws is that the offences, or the offence which is relevant to the present appeal, is 4.1a, a member, and I omit immaterial words, shall be liable to disciplinary action under these bylaws in any of the following cases, and then the proviso to make certain that persons can't resign to elude the reach of the institute. A, if in the course of carrying out professional work or otherwise he's committed any act or default likely to bring discredit on himself, the institute, or the profession of accountancy. And as Mr. Curl rightly said, it was thought impractical, as indeed it would be, to describe each and every act or default that might be likely to bring discredit on a member of the institute or the profession. And therefore, as it were, as long as a complaint was made that was rationally capable of constituting something that was an act or default likely to bring discredit, etc., that was within the varies of the institute as a prosecuting authority. One then goes to Article 7.1. This is not, I readily concede, the most elegantly drafted provision, but in our respectful submission, once properly construed, its sense is clear. The fact that a member has, before a court of competent jurisdiction, pleaded guilty to or been found guilty of an indictable offence shall, for the purposes of an offence corresponding to one which is indictable in England and Wales, shall, for the purposes of these bylaws, be conclusive evidence of the commission by him of such act or default as is mentioned in bylaw 4.1a. Now, what is clear is that there is, as it were, no further elaboration as to what is the act or default mentioned in 4.1a than one finds in the text of Article 7.1 itself. And in our respectful submission, awkwardly drafted though it is, the act or default, the commission of which is mentioned, is the fact that he has been found guilty of an indictable offence with the relevant indicia that are then set out.
How can that fact be an act or default?
That's how it's defined. That, with great respect, is the way in which it is defined. The fact is, shall be conclusive evidence of the commission by him of such an act. I readily accept that a conviction by itself could not be an act. But being found convicted is, without torturing the English language unduly, something that is capable of being an act.
But the heading is proof of certain matters.
Yes, absolutely. What's it proof of? It is proof, as indeed the entirety of 7 is concerned with, proof of certain matters which are proof of something that falls within 4.1a. And whether one is looking at 7.1 or looking at 7.3, neither of them specify what it is that is going to be the act or default which is discreditable within the meaning of 4.1a. And what we say is 7.1, as it were, as the President said, it actually both defines the act or default and the way by which it is to be proved. And there is, with respect, no reason why that should not be so.
But what happens in the case of proceedings which rely upon 7.1 successfully?
Yes.
First of all, how about the sanction that's imposed? How does the tribunal set about imposing a sanction?
How they set about imposing a sanction
Yes.
after they've after that's been, after the offence
He's
has
been convicted
proved.
of theft.
Yes.
It may be of 10p from the
Yes.
counter of a grocer's store, or it may be of £50,000.
And at that stage, they consider all circumstances in the context of mitigation. Indeed, one of the submissions made by Mr. Curl against which we rebel is the suggestion that mitigation and liability as it were two sides of the same coin. It's perfectly capable of having a structure as this is, which opens the door to finding that you committed a discreditable act. And then when you get to deciding what are we going to do about it, you can, of course, introduce all the material that goes to the background, the mitigation.
Well, the first question is, what is the act?
Well, yes. Well, I'll show you the complaint in a moment, but because, in fact, in our respectful submission, it's quite clear what the act is within terms of the article. All I'm saying is this article does allow the Institute, for good and sufficient reason, to say that the act is the fact that the member has been found guilty of an indictable offence with the relevant indicia.
Your construction is supported by the double criminality requirement because if it were an independent act, you wouldn't need double criminality.
Yes, at any rate, it needs some purchase somewhere, and one can't, with respect, find anything else. My learned friend says, well, of course, it's the conduct. But actually, again, if you look at 7.3, which is a method of proving conduct, one equally, all that is a finding of fact, shall for the purposes of the prima facie of the evidence of facts found. One still has to weave those facts into something.
Well, that proves fact, but it doesn't prove that they're discreditable, whereas your conviction proves the discreditable element as well. But assume that you're wrong, that autrefois convict does apply to disciplinary proceedings. And in this case, there had been a indictable offence in this country which matched the one in Jersey. And the appellant had been struck off for 6 years. Could any further proceedings for the facts have been brought?
No.
And one reason why not would be that it would be met by autrefois convict.
No, it might be met by abuse of process, with respect.
Well,
because if...
why wouldn't it be autrefois convict?
Well,
I think you have to argue it wouldn't be.
It would be autrefois convict if one sought to resurrect the conviction. It would not be autrefois acquit if one went to the conduct behind the conviction, but undoubtedly it would be an abuse of process. But if one had succeeded first time round and explanations had been volunteered as to the circumstance that led to the conviction, the Institute would have known everything they needed to know. And indeed, as we say, it's very difficult to envisage any rational body, such as the Institute, even considering a second set of proceedings, simply basing themselves on the conduct that underlay the conviction. That's the point. But it would be, I would say it would be abusive, not, as I say, I don't accept it's autrefois acquit, but that in a sense matters not, because res judicata with the civil equivalent, and I shall have to come to consider in my alternative. This, my primary point is that my learned friend's threshold, the starting point is simply, with respect, wrong. And can I just take you to the complaint? Because what I found, with great respect, so interesting, is that my lords, in testing my learned friend's proposition, read out of the complaint the very words that we thought were critical. Can we go to the first? I mean, let us just juxtapose these two complaints. The first one you find at tab 9 of 6. He's liable to disciplinary action under bylaw 41A, namely, and this of course is conventional because that's simply a repetition of the nature of disciplinary, of a discreditable act. And that's the starting point in every circumstance in this type of case. Now, why is he liable? Of course, in that. So what they're saying is, this is why it's discreditable conduct, in that he was convicted upon indictment at the Royal Court of Jersey on such and such. Now, my Lord Clark, for example, put to my friend and said, well, that's surplusage. But with great respect, far from being surplusage, it's actually critical. One might, if one was a purist, say, well, what comes after is surplusage, but it's there actually simply to identify what it was of what he was convicted. So you know you've got, as it were, the right conviction.
Yes, well, that just
It just
shows
describes
what was in the mind of the person who typed this in, but it might be that this should properly have stated, in that he failed to comply with the direction, etc., as proved by his conviction for that offence in
Well,
Jersey.
but we say no because given the vocabulary of 7.1, we say that the discreditable act is in fact in that he was convicted on indictment. That's what, linking it, that's what saying, that's what was
I mean,
discredited.
the point I put assumes that your construction of Rule 7.1 is wrong.
Yes, of course.
I mean, if it were right, then the position might be different.
Yes. But it's
But
not
if we were to hold that it's wrong, then I maintain the point,
well, absolutely. I'm not
which is
sure
a possibility I don't think you should overlook.
Have I suggested in this or any other appeal, by the way, overlook a point? Sometimes the points are found ultimately in my
Mr. Beloff,
favour.
isn't the point of 7.1, the word conclusive
Yeah.
is very important and to be contrasted with prima facie evidence in 7.3.
Yes.
And it seems to me that the point of 7.1 is as the heading to the section says, proof of certain rights. It's all about proof.
Yes.
And it is saying that in relation to a 4.1a act or default,
Yes.
then you can conclusively prove it by producing evidence of a conviction.
Yes, but it doesn't. I'm sorry.
Sorry, no, go on.
It doesn't answer the question, then what is the discreditable act? Your Lordship's formulation is quite right
Yes.
as far as
Yes.
it goes. The next question is,
Yes.
what is the discreditable
Well,
act?
you have to assert
And
and prove it.
It's internal to it, because it's internal to Article 7.1.
Well, if it doesn't, if you're right, it doesn't have to be conclusive at all. It's not, a conviction isn't conclusive of itself.
Well, I mean, that may be, when we say it's not conclusive of
It's
itself.
not conclusive evidence of the conviction.
No,
Because-
what it's conclusive evidence of is a discreditable act. That's to say that you have been found guilty by a court with certain indicia.
That's circular. Conviction is conclusive evidence that you've been convicted.
Yes.
That's axiomatic.
I mean, are you saying the only way in which you can prove a breach of 4.1a is through the 7.1 gateway?
No, I'm
So,
not.
well then,
No, I'm-
all right, well then-
No, but what I'm saying is, actually there are two separate offences here. There's the umbrella, the discreditable conduct. Now, there are innumerable matters that could constitute discreditable conduct. I mean, it would be absurd, for example, to say, well, because he's been acquitted of discreditable conduct under this, let's say someone's accused or charged with theft and is acquitted before the tribunal, and then subsequently commits an act of embezzlement. No one could say, oh, well, you've already been acquitted of discreditable conduct under 4.1a, and therefore there can never be a second case. The real question is whether one can identify different offences. One offence, I'm talking the language of discipline, one offence can be the fact that you've been convicted. Enough. It's discreditable. Persons who are members of an honourable profession should not find themselves convicted. The other is to say, you've committed certain conduct which is discreditable. Here, the conduct would be the facts that were found by the Jersey court. That's to say, in breach of a direction, flagrant breach of a direction given by the Jersey Financial Services Commission.
Just take an example, causing death by dangerous driving.
Yes.
We'll take two examples, one embezzlement
Yes.
and another causing death by dangerous driving.
Yes.
How would you approach, would they be approached differently under 4.1a?
No, I don't. No, you're perfectly entitled to seek to establish simply the conviction. The error here was that there was an element of the offence that we say is defined or embedded in 7.1 that was missing. Not that the Jersey court, mercifully, was not a court of competent jurisdiction, but there was not a corresponding offence.
But does a breach of 4.1a have to be a criminal offence?
No, of course not.
Well,
Of course
that's what
it
I thought you'd say, but then I don't understand, because your whole argument, as I understand it, is that 7.1a doesn't tell you anything about, I'm sorry, that the 4.1a doesn't tell you what is the kind of act or default of discrediting that it's talking about.
Yeah.
You say that is provided, that information is provided, at any rate in this case, by 7.1. By 7.1.
Yes.
But in a case which didn't involve any criminal conviction at all, how would it happen?
How would you establish something?
How would you establish what was the act or
You would,
or default?
that's very easy.
Yeah.
If there were a conviction, but of course it didn't have the extra element of the corresponding offence, it's really, as it were, what the second complaint dealt with. They said, right, we can use the findings of the Royal Court of Jersey as prima facie evidence of certain facts. Bear in mind, as already been alluded to by, I think, by picking my Lord Clerk, a finding of fact and the conviction actually are treated separately in this. So what you would do in that particular case is, if there were a court, a competent court, civil or criminal, who'd made certain findings, you start prima facie, we can rely upon those findings. If the defendant to the charge says, I dispute those, then you're faced with the need to gather together all the evidence that led to the court making those findings and such supplementary evidence as you think would sustain the charge. Or there may be another case in which there's been no finding by any court of competent jurisdiction or any court at all, in which case you bring a charge, bringing evidence in the ordinary way, such admissible evidence as permitted under the rules.
Well, there may be the finding of a civil court.
Yes, it could be a civil court. Or indeed it could be the bodies referred to in subsection 4. Those are regulatory bodies. So there's a whole range of possibilities. But I'm not suggesting for a single second that the Institute can only bring disciplinary proceedings on the basis of a conviction. All I'm saying is that, in fact, the conviction is, the fact that someone's been found guilty is the act or default that is mentioned. And indeed, with great respect, there is nothing unusual in that. You may find that the drafting is not perfect, but I can show you in the bundles at least 3 cases, indeed Harry Wee may be a 4th, in which this is perfectly conventional. The pharmacy case, presided over by former Lord Chief Justice Lord Lane. There is the solicitor's profession, again, and the police officer's case, Madden and Roan. They're all in the bundles, and all of them have a perfectly familiar pattern that to be convicted is of itself an offence under our code.
Well, it
No,
could
it's
so
not.
provide.
It
Could so provide. The
Yes,
question is
the
whether
only
it
question
does.
is, well, I quite agree that, as I say, the only question is whether one takes, I'm not going to be offensive and say a sensible and purposive interpretation, trying to see what this is actually driving at.
Respect, Mr. Barrett. Conviction isn't. It is conclusive proof.
Yeah.
Conclusive evidence that you have committed an act. I mean, it's not, the conviction isn't itself the act, but it's conclusive proof that you have committed one of the acts which falls inside 4.1a. That's what it
Yes.
says.
Yes, but it still doesn't answer the question, what is the act?
No, I mean, but I mean that if you have such a thing, then you don't need to ask anything more. You know thereby that it has been proved that you have done something which falls
That's
within
right.
4.1a. I'm simply quibbling, if you like, with the way you said it amounted to the act. It's not the conviction, it's just proof. It is conclusive proof.
Yes.
But you're construing it as if it was one of the factors in Regulation 4.1e. 4.1e says one of the circumstances is if any of the circumstances set out in paragraph 2 exist. Yeah. And then, if you were right, you'd expect in subparagraph 2 it to say, to refer to the conviction, because then the conviction would be the offence, if you like, which it could be.
Well, let me put it this way. I mean, maybe what my Lord Roger is putting to me is actually in my favour.
It is in your
I
favour,
thought it
Mr.
might be, but it's a more sophisticated
At least
way.
it was intended to
Yes,
be.
it was a naturally more sophisticated way than I was putting it. What I'm very concerned to drive at is that there is a clear distinction between the first complaint and the second complaint, which is rooted in the language of the bylaws as it had to be. And what I do say is that if you look at the first complaint, that in that he was convicted upon indictment identifies that which is the discreditable act.
What, the facts of the conviction?
Yes, yes. That's it. It is conclusive proof.
It's conclusive
It's
proof.
And really, my lord, as I say, what came after in the sentence just to describe the offence? Well,
Yes, but it's
that's
not the
fine.
offence.
Sorry?
It's not the offence. It's not itself
No,
the breach.
no, it's
it's
not.
only conclusive proof of the breach, which
Yes.
are two conceptually quite different things.
Yeah, but my lord, as it were, goes, as it were, smooths over a particular intervening stage. I don't say it's conclusive evidence of the breach, and indeed that is not the language of Article 7.1 or indeed of the complaint. It's conclusive proof, as my Lord Roger put to me, of a commission of an act discreditable to the profession. If one then wanted to ask further, well, what is actually meant by that, then you have my rather cruder analysis, is saying what's actually meant is the fact you've been convicted. It's not something that...
But so long as you accept that it's conclusive proof, I maintain my point that it's an immaterial averment.
Yeah. No, it's not an immaterial averment because you've got to prove it in some way.
No, because it's not something you need to aver. It's just the method of proving the averment. The averment being the breach of the regulation, or acting inappropriately, whatever is it.
Well, as long as one's talking about, I see, if your lordship is talking about a breach of 4.1a, then I accept it. I thought for a moment your lordship was talking about a breach of the Jersey direction or something of that kind.
No, I'm talking about 4.1a.
Yeah, yes. Yeah. But that's how it's done. Now, I agree. For example, the summary of the complaint that comes afterwards is simply surplusage. It's not actually relevant to what's being charged at all. No doubt it was thought to be helpful. But one can't, as it were, transform the actual charge itself by some unnecessary surplusage.
What about paragraph 14, which restates the complaint?
Yeah, has been convicted. His conviction is conclusive. Well, then it just restates the problem. Well, not the problem. It just restates its conclusive evidence by the commission of such an act. And what is the act there? That he's been convicted. I mean, the sentence is entirely at one with the analysis I venture. And if one then goes to the other complaint, which your lordships find in the same...
Just before we do, if you have your ordinary criminal indictment,
Yeah.
the indictment charges an offence against Section 4 of the Theft Act, and then particulars.
Yes.
And if you had an issue of autrefois, acquit or convict, the court would look at the particulars to see what it was that you were charged of.
Absolutely. And I accept that. And what I am saying is, if you look at the first complaint, what he was being charged with was the fact he'd been convicted. And if someone sought to bring a second complaint on that, it would immediately be struck out, or he'd be immediately vulnerable to a res judicata. Whatever had happened one way or the other, I don't dispute if they got it wrong, that would equally be, as long as they'd addressed them. I mean, as long as one accepts what it is that was in issue before them. I mean, they can't veer out of it. I think they understood that. I'm going to come to what they said when we get to the second alternative point about the merits point. But if you look then at the second complaint, you can see, I mean, with great respect, it's on its face quite different. Because here, the second complaint is, and again, look, this is tab 12 of 6 of 12, 12 of 6.
12 of 6, yes.
What is it? Once again, one starts off with the relatively elastic bylaw for 1A, and then to borrow, my lord, Philip thought, what are the particulars there, what is the disciplinary, he's committed the act, etc., in that he. So you're now being told what it is that the act or default like to be credited, and then one sees there they actually mention what it was that he had actually been found to do in the Jersey court, but they don't even refer there to the conviction. They just simply say, on a particular date, you attempted to remove the particular items in contravention of the particular directive that had been issued under the particular law. So that was it. And one can see with respect, I can quite understand your lordship.
Is that what he was convicted of?
That is what he was convicted
Have
of.
we got a note of the conviction? Do we know precisely what? Have we got a document which shows?
You've got the refusal of the leave to appeal by the Jersey Court.
Is there a
of Appeal.
certificate
I
of
think
this?
Mr. Carroll suggested.
Yes, I think it's
Seeing myself,
my
it would be helpful to look at it.
quite help. Yes, I'm quite happy for that to be put in. You've got some copies of it. Thank you very much. Have you given it to the court?
Thank you.
Well, there one has it, perhaps not a very surprising document. The particulars of the conviction, one count of failure to comply with the direction issued, etc., date and place where it was committed, there it is, and the greffier substitute has certified that from the...
Have we got, where do we see the direction?
That is in the bundle, yes, it's in appendix. Well, actually, I've got it in my note. I can help Miss Callahan. The direction itself is to be found at Appendix 2 at pages 350 and 356. What's Appendix 2? Oh, no, I've got Appendix 2. Am I right at 351 and 356? No. I think I am. Yes, at 350 and 351, one sees the 18th of December direction signed by the Director General and the Deputy Director General. That's at 351. And there are a variety of directions, but the one that's material to my Lord's question is at 7 across at page 350. No records or files in respect of the companies or any customers shall be removed from the offices of the companies. So that's the 18th December direction, of which there was then a breach. And the evidence of service, if my Lord's interested in the background facts, or well, the statement of services in relation at page 356. And I don't think it has ever
The allegations in the criminal proceedings
Yes.
asserted the removal, did they, of the documents referred to at page 107?
Yes. Yes.
They did. So they're the very same documents.
As far as I'm aware, yes. I don't think there are any... I mean, one finds, if you're also interested in this, the Jersey Court of Appeal, provided over on that occasion by Mr. Richard Southwell of Queen's Counsel, sets out in detail what the background facts were and why it was that they determined that there was no basis for allowing an appeal to go forward. Again, that's a document that one finds in Appendix 1 at tab 8. Yeah. At 395, again, if one's going back into the facts, just for interest in any event, 395 of the same bundle that I was inviting your attention to, Appendix Part 2, are the documents which were removed. were sought to be removed. They were certainly removed from the offices. They were sought to be removed from Jersey, unsuccessfully. We've got the judgment, it's in Appendix 2. Appendix 1. No, it's Appendix 1 at tab 8. Sorry? Yes, apparently it's thought that your Lordship's copies may be a little indistinct, and we can provide substitute copies if you wish. But what one will see is that the judgment was given by the President, Mr. Southwell, Queen's Counsel. They give the background. They note at paragraph 5 that Mr. Coke-Wallis chose not to give evidence, that at the end of paragraph 5. There was then the issue was, were the directions served or not served? That was really the substantive issue. The jurats, as you know, came to the conclusion that Mr. Coke-Wallis, certainly that Mrs. Coke-Wallis was served, and that Mr. Coke-Wallis would have become aware of that service. And one sees that at paragraph 23, where a whole series of sub-particulars are relied upon to show that the jurats were entitled to come to the conclusion which they did. And they also note, again at paragraph 24, faced with the evidence from which the jurats were entitled to refer the requisite knowledge of the relevant direction, Mr. Coke-Wallis chose not to give evidence, as was his right. The jurats therefore had no evidence to rebut the inferences they were entitled to draw, except that of Mrs. Coke-Wallis, whom they disbelieved. And then the first sentence, they were fully entitled to reject the submission that Mrs. Coke-Wallis had not informed her husband of the direction.
One last question. Have you got a cross-reference to the witness statement referred to on page 107?
Your Lordship is testing me hard, but I no doubt Miss Callaghan can assist. The witness statement of Mr. Beamish.
Yeah.
Yeah, appendix part 2. Sorry. I'm quite happy to have any assistance from my right that can be. We have got a statement from Mr. Beamish somewhere. That's Mrs. Hatton's statement. Well, I don't know if it's helpful. But if it's 397. Miss Callaghan to the rescue. Yes, thank you very much indeed. Yeah, what he says at the second page, 398, he identifies as that those being effectively precisely the kind of documents that the direction said that Mr. Coke-Wallis should not remove.
And these form the basis of the prosecution, these very documents.
The prosecution, yes.
Thank you.
I mean, as I understand, Mr. Beloff, where all this must lead to is a suggestion that somehow or other you're not trying to, they weren't trying to prove the same thing. Is that
Absolutely.
Right?
I mean,
is that right?
That's exactly what I am seeking to say. And as I say, if one starts, one starts, as I say, with the bylaws, but if one simply looks on the face of the two complaints, one can see that the discreditable conduct, which, as my Lord the President says, is revealed by the particulars, that's to say, that which comes after the reference to the disciplinary bylaw, in that he, and then one looks, and one of them says, in that he was convicted, etc., and the other which says, in that he did something.
But the underlying facts are identical in the two cases. Absolutely identical.
The underlying...
No differences whatever.
Well, no, they aren't, of course. they are identical. But of course, that doesn't mean that the charge is identical, because one of them focuses on the fact that you were convicted, and the other focuses on the breach of the direction. And
But you couldn't be sentenced for the conviction, could you? You could only be sentenced, or indeed the disciplinary tribunal could only have regard to the substantive counts, not the fact of the conviction, couldn't it?
With respect, they could be... No, with great respect, I disagree. I say that the fact that he's been convicted is of itself commission of an act, a discreditable act. They then, of course, come to sanction, and at that juncture, no doubt, explanations could be given, if Mr. Coke-Wallis ever chose to give explanations viva voce to the tribunal, as to mitigating circumstances.
At that juncture, it would be essential, first of all, to consider the underlying fact for which he had been convicted.
Yes.
You couldn't proceed with the exercise of deciding the appropriate sanction without looking at that fact.
I agree, of course.
And you couldn't increase the sanction because of the fact of the conviction.
No, I agree. My Lord, of course, Mr. Coke-Wallis is given opportunity to come to meet the point. And indeed, such written submissions as he made would no doubt have been taken into account by the first tribunal had they not considered that the way in which the charge was formulated could not be brought home because an essential ingredient, the equivalent offence, was lacking.
But that may be the answer to something that was troubling me, which is what is it conclusive evidence of? Because it does mean that for all sorts of other purposes, the professional person can't go behind the conviction and say, oh, well, I shouldn't have such a large penalty because actually I was innocent.
Yeah. Well, it's conclusive evidence of a discreditable act.
Yes.
I mean, he
For a
can't,
number of
you're-
different
you're
purposes,
quite right.
not only for 418.
Yes, he can't go... No, you're right, he can't...
Well, is any conclusive evidence of a discreditable act, if it is a discreditable act?
Yes. Well, no, with respect, no. They have so structured it that the discreditable act is the fact of being convicted.
But any discreditable act, I mean, driving your car, or what?
No, with great respect, no. It's being convicted by a court of competent jurisdiction of an equivalent offence. So you'd need all those three elements in. And
Yes,
of course,
but the offence would have to satisfy Regulation 41A.
No, it's
Yeah, that would be a matter
any
for the-
indictable offence does.
Yes.
Sorry, any indictable offence, but the indictable offence would have to satisfy Section 41A.
No, it's
couldn't be
conclusive.
murder, could it?
Why not?
Yes. Why not?
Or-
I mean, I'd rather hope
Because it's-
that those are
It's in the
characters,
course of
and
carrying
they
out
are
or
few
otherwise.
who indulge in acts of murder would not escape.
I certainly
maybe right.
read the conclusive
Yeah.
proof as being proof not merely of at least an act, but of a discreditable act.
Yes, I agree. I agree. And let's also be clear, but my Lord Orcark is troubled by this. Look at the indicia which have to be satisfied. It has to be an indictable offence. It has to be a court of competent jurisdiction. And then, of course, there's the twist in the tail. It has to have an equivalent in this country. But I mean, the very fact that it's A, indictable, means that it's serious, and B, it's a court of competent jurisdiction means, to use the vernacular, that no kangaroo court is going to qualify for that purpose. And actually, they do add in, because they recognise, no doubt, the possibility that in different jurisdictions there are different offences. For example, your Lordship is far more familiar, I suspect, with the kinds of offences in American financial services law, which are probably wider reaching than ours. They've got to have some equivalent in this country.
If this were extradition, one would be, under the old double criminality, one would be actually looking at the facts
Yes.
and asking, do the facts
That's
constitute?
true. That's true.
an
And
offence?
But here, another drafting technique has been used.
Yes.
And there's no, if I say so, if this form, 4.1a, the idea that a conviction by a court of competent jurisdiction, indictable offence equivalent, constituted itself a discreditable act, if someone in the profession were to say, this is perverse, but no responsible regulator can put us in jeopardy on such a basis, no doubt they could take the proceedings, but they would be bound to be unsuccessful because one cannot see any court saying that no rational regulator could say that it was not a serious act of misconduct to be convicted of, etc., etc.
It's 4 o'clock, let's
I thought your lordships would be pleased by that.
He's right about the last point. He is right about the last. Well, not. The point I was putting was